I do want to give everybody about a minute to provide some key takeaways of their segment. We're going to do it in the order of the presentation. So, Jennifer Riddle, we'll start with you. Some key takeaways, please, in about a minute.
Yep. So, the key takeaways from my presentation is that DOJ continues to, attempt to provide further guidance on its FCPA enforcement practice. We had the Corporate Enforcement Policy announced in November of 2017. Most recently, we had this newly announced policy against DOJ piling on. There are, in addition, there's been a number of themes that we've seen in 2017 and now continuing into this year. And those themes are multi-jurisdictional resolutions. We'll continue to see increased coordination between DOJ and enforcement authorities in a number of other countries. In 2017, some of our largest resolutions were all multi-jurisdictional in nature. We talked about the theme of the imposition of corporate monitors, and this was addressed in a new corporate enforcement policy. The monitors would not be required where the company has demonstrated that it has implemented an effective compliance program at the time of the resolution. And in fact, we actually saw that play out in those major resolutions in 2017, where we had a number of, large major resolutions, but no corporate monitor required. Another theme we talked about were the individual prosecutions, and that continues to be a focus of DOJ in 2017 and now this year. 2017, we saw a number of actions against several high-level executives, and DOJ guidance is rewarding companies that cooperate with DOJ in actions against culpable employees. And then finally, we had some recent court opinions that raised some new concerns about the way in which companies can cooperate with DOJ and whether such cooperation could actually jeopardize privilege protections. And that was in our discussion about oral downloads or readouts of internal and privileged materials such as internal investigation interviews.
Thank you for that, Jennifer. Jason Gray, about a minute for some key takeaways.
Sure. Thanks, Al. I think the first takeaway from my presentation is that companies that are subject to the accounting provisions of the FCPA, you need to be aware and conscious of the broad interpretation of those provisions by the SEC. As we saw from the cases that we went through, the broad interpretation of those provisions really has the potential to impact a wide array of company activities, including how you supervise and monitor the activities of your foreign subsidiaries, how you integrate new acquisitions into your global compliance program and existing internal controls, how you respond to internal audit reports, how you conduct due diligence on third parties, whether you retain records of that diligence on third parties, and whether or not senior management of your overseas subsidiaries are trained on compliance matters. The SEC has really shown it's interested in pursuing these FCPA cases where companies have not maintained compliance programs that adequately incorporate these sort of considerations, even in the absence of evidence of bribery or other improper activities. The second sort of takeaway or observation, perhaps, is that I think watch this space for how the DOJ approaches the corporate enforcement policy in terms of the request for companies to prohibit the use of self-destructing apps and services. Certainly as someone whose practice is based in the Asian region, where services like WeChat and Line are very pervasive, it's going to be interesting to see how this issue is tackled going forward. And finally, I guess, as I sort of mentioned at the end of my slides, more and more jurisdictions are developing or amending their foreign bribery regimes. Countries in the Asia-Pacific region are certainly no exception, and companies need to make sure that they're aware of local enforcement risk and not just FCPA liability. And certainly the recent changes to China's ABC laws and institutions only serve to emphasize that issue.
Thank you, Jason Gray. Clay Porter, a minute for some key takeaways, please.
At the end of the day, when you walk into the government and you want to present on your compliance program and you want to present on what you may have found in your internal investigation, it's very helpful to have subject matter experts be a part of the investigation and work hand in hand with the lawyers. It allows the government to see that subject matter experts are pulling apart the issues, walking the transactions through, and understanding where the transactions started and ended up and what their purpose was. And in addition, you'll also be able to test the government if the government's theory is too aggressive. The subject matter expert could write a report that you could submit to the government, and the government will then have to have a discussion about that. But certainly it's very helpful if even when you're headed into resolution time.